to what is our last session of our AI Tech and Policy Talks of this year. For those of you who are not familiar with our AITPT webinar series, the AITPT initiative was launched at our Digital Law Center, and its ambitions to offer a forum for policy debate and discussion about selected cutting-edge AI-related policy issues in an interdisciplinary manner. So we're very pleased to continue this type of event. And we're very pleased to organize this session of AITPT in cooperation with the Geneva Master in International Dispute Settlement. And I see MIDS colleagues who have just joined us, and also with the MIDS Alumni Association, MAA. And I just wanted from the outset to thank our MIDS colleague and MIDS alumni colleague for this opportunity to cooperate, and also to warmly welcome members of the MIDS community to our session today. So today we have the great pleasure to welcome as our distinguished speaker for this session, Claire Morel de Westgaver, who is a partner at the firm Bryan, Leighton, Paisner in London. And she will talk about a very hot topic, which is the use of AI in international arbitration. As to her title, will transparency make the algorithm fair? And Claire Morel de Westgaver will present and discuss the results of the annual arbitration survey that her firm has conducted and that has just been published. And the survey is available online, and we will share now the link to the survey if that is of interest to you. As done usually in our AITPT session, the presentation by our presenter will be followed by comments made by distinguished commentators. And today we are very pleased and honored to welcome Benjamin Malek, who is arbitrator at T.H.E. Chambers in New York City, New York-based law firm, and who also is, quite importantly, the chair of the Silicon Valley Arbitration Mediation Center AI Task Force, who has, as some of you may know, submitted for public comments draft AI guidelines, and we will be sharing the link to the guidelines as well as to the website on which you can put your own comments, knowing that the deadline for submission of the comments is running until December 15th. So that's basically an opportunity, last opportunity perhaps, to also engage in the discussion in addition to the session today. And as a second commentator, we'll also have the privilege to welcome and to hear Professor Pietro Ortolani, who is a full professor of digital conflict resolution at Radboud University in the Netherlands. So it's a great privilege also to welcome him for the session today. And as those familiar with our AITPT session know, after the comments made by the commentators, we'll of course have an opportunity to interact with the speaker and the commentators in a quite informal manner, as done in the past. And we can use the raise the hand function that I'm sure you all know on the Zoom platform. Please note that the plan is to record and to make available the session online for those interested people who have not been in a position to join it today. So this is what you see also at the top of the screen, as I'm sure you know. And finally, as some of you have already kindly done, we would invite everyone to please turn the camera on as a matter of courtesy to the speaker as well as to the commentators. And now, without further ado, I would give the floor to you, Claire, for the presentation, and then we'll follow by the commentators. Thank you very much.
Thank you, Jacques. Thank you all for joining. I'm delighted to be here with you. Let me start by sharing my screen so you can see my slides, and let's hope it works as it should. Can you see them?
Yes. Perfect.
Great. So the use of artificial intelligence in international arbitration will transparency make the algorithm fair. Let me make sure it moves. So you may know that for the last 5 years or so, 15 years or so, my firm has been conducting surveys on arbitration topics. And this year, the topic of the survey was AI. So the survey launched in the spring, was open for a couple of months, closed in the summer, and we launched the results, so the report setting out the results in November last month. So my presentation will focus on the survey itself and the findings. As far as I'm aware, it's the first and only survey on this very topic of the use of AI in arbitration. Therefore, my view at least is that the findings provide invaluable information and data on various issues to which the use of AI in arbitration give rise. So I therefore propose to proceed as follows. I will go through some information about the respondents, people who took the survey. Will then share the key findings. And then I will finish by sharing some thoughts, potentially lessons, takeaways we can digest, think about, and hopefully take forward in the form of projects or further discussion. So let's start with the respondents. This year we had 220 responses to the survey. If any people in the audience have taken the survey, thank you very much. Your participation is extremely appreciated. We have some slides here, so some data on who those 221 respondents were. First, information on their legal background. 57 of them were from a common law background, 13 from a civil law background, and 23 had both a common law and civil law background. Then the nature of the involvement in arbitration. For this question and the question about the sectors, people could choose as many answers as they wish. So you will notice that the percentages actually don't add up. And just a few highlights. So 54% were lawyers from working in law firms, 33% were arbitrators, and 12% were in-house counsel. In terms of regions and sectors, respondents worked across a wide number of regions and were involved in disputes across a wide range of sectors. 69% were from Western Europe, 28% from the Middle East, and 22% were located in North America. 62% were involved in disputes in the construction and engineering sector, 53% in energy, natural resources, and 38% in international trade and commodities. And finally, but not least, 38% in technology, which in my view is an area where there are more and more disputes submitted to arbitration. This year, for the first time in 15 years, we actually asked respondents to tell us their age. We did this because we wanted to see the impact, if any, that age had or may have on the responses and the use of AI. We were very grateful that all 221 respondents were willing to provide this information. And the slides here shows the breakdown. The next finding or question was relating to ChatGPT. There would be no survey on AI. No survey on AI would be complete without a question on ChatGPT. As you know, ChatGPT was launched just a year ago in November 2022 by OpenAI. And the launch of ChatGPT was described as watershed moment for AI. And I think it's fair to say that it probably is what ultimately prompted us to to actually conduct this survey on AI, because as I'm sure you will agree, in the last year there's been so many developments in AI more broadly, but also in AI in arbitration. And so we asked, we asked people if they had used ChatGPT in the professional context, in this case, arbitration. And I think important to note here that 28% of respondents had used ChatGPT in a professional context, 72 had not. And then you have the age breakdown here as well. Moving on to the use of AI tools to perform tasks in arbitration. Here we faced an important challenge in the preparation of the survey, which is defining AI, which we can discuss that later on. In my view, will potentially constitute the most difficult task for all of us, counsel, parties, arbitrators, to define AI when it comes to making some rulings, when requiring party to disclose AI. Defining AI would be very important and will prompt to many, I'm sure, arguments. So we've defined AI very broadly, and this, of course, this definition kind of carries through the entire survey. Then we canvassed views on what tasks AI tools are currently being used in arbitration, what tasks AI tools may be used in the future, and where people would draw the line on the use of AI tools to perform tasks. So it's quite a busy slide here. So I will take you through it, because overall, what it shows, in my view, is that actually AI is already being used, I would say significantly, in arbitration, at least for certain tasks. So let's start by that. And if you can look at the highlight, the green highlight here, here we've highlighted 3 areas of current use. 30% of respondents had already used AI tools for document review and production, 38% for translation of documents, and 30% for text formatting and editing. We've also highlighted 3 top areas for potential future use. So areas where respondents have not yet used an AI tool to perform a task, but would have no objection to doing so in the future. 80% of respondents would use AI tool to detect whether AI has been used to generate materials, 73% for generation of factual summaries, and 68% for document analysis. So here, no objection, but not so much used yet. And then finally, the areas I highlighted in red here relates to areas where respondents would actually draw a line. And so these were focused on the use of AI tools to generate text. So in particular, we wanted to highlight, 3 of them. 62% didn't think that AI tools should be used to generate text for use in arbitral awards. We'll come back to that. 58% didn't think they should be used to generate text for use in expert reports. So, and then finally, 53% didn't think they should use AI to generate text for use in legal submissions. So you may want to keep those in mind for discussion later on. Moving on to benefits and risks. We asked respondents about the perceived benefits of using AI tools in arbitration. No real surprise here. I mean, the big winner is obviously efficiency. 62% of respondents ranked efficiency as the most important benefits. Actually, 85% of respondents ranked it as the most and the second most important benefits. And then cost effectiveness came in second, with 60% of respondents ranking it as the most or the second most important benefits. Here we wanted to highlight some finding in relation to in-house counsel in particular. 65% of in-house counsel respondents ranked saving time as the most and second most important benefits of using AI. And 30% of in-house counsel ranked the ability to perform a task in-house without having to outsourcing it to outside counsel as the most important benefit, ranking it for third or fourth position. So now, enough with benefits, let's turn to risks. The top areas for concerns were cybersecurity, AI hallucinations, confidentiality, and deepfakes. 88% of respondents were very concerned or somewhat concerned about security risks. 88% were very concerned or somewhat concerned about AI hallucinations, so the risk of AI tool conjuring up fictitious information. 87.5% were concerned or somewhat concerned about a breach of confidentiality. And finally, 86% were concerned about deepfake. So the risk of AI tool being used to create false evidence or at least tampering with evidence. So this slide relates to two questions that focused on understanding how AI makes decision, a concept that's often referred to as the black box issue. And so here the first question related to how important people thought that understanding how the AI tools make decision is. And 90% of respondents thought that it was important to understand how AI tools make decision. So either they ranked it as 7 or above. And you can see here that 69% said that they ranked themselves as 5 or below as to their own ability to understand how AI tool makes decisions. So you can see that here what we were looking at is how important it is, but then how little confident people were about how they if they understand how the AI makes this decision. So the next question is related to disclosure of the use of AI tools. So that relates to the simple fact that, as a party in arbitration, you'd need potentially, if there is a duty to do so, to disclose if you have used AI on your side. So here, 60% of people agreed or strongly agreed that there is a need for greater transparency over the use of AI tools by parties in arbitration. So that was kind of the general thinking here. To go a bit deeper, 72% agreed or strongly agreed that parties should be required to disclose the use of AI tools for drafting expert reports. We can think we can kind of guess why, right? Because it has a direct impact on evidence. 65% agreed or strongly agreed that the party should be required to disclose the use of AI tools for document review and production. 62% agree or strongly agree that the party should be required to disclose the use of AI tools for translation of documents submitted in the arbitration records. And finally, 40% agreed or strongly agreed about disclosure of AI tools for legal research, which is, I think, an interesting one, given that a lot of research tools already have AI embedded in their features, and sometimes the user actually does not realize that AI is effectively forms part of the legal research tool. We then asked to whom disclosure of the use of AI should be given, 50%, so somewhat actually a small percentage, thought that disclosure should be given to all participants in the arbitration, including their own client, parties to the arbitration, the tribunal, the administering institution, and other associated or third-party funders or insurers. And then 12% thought that disclosure was not necessary at all. Then we wanted to also find out about arbitrators' technical competence, because we've noticed that in recent years, arbitrators' tech savviness, so competence, has become increasingly an important consideration in arbitrator selection. So we've asked respondents how confident they were in technical capability of arbitrators to give directions and to rule on some AI related issues. There's somebody who is not on mute, so maybe they can do that if they can mute themselves. Thank you. And here, only 15% rated their confidence in the technical abilities of arbitrators at 7 or above. So again, that shows that people are generally not so confident in arbitrators' technical confidence. And 79% of respondents rated their confidence in technical capabilities of arbitrators at 5 or below. Hang on, that was here. Sorry, yeah, I jumped ahead of myself here. And then we then asked questions about on the use of AI by arbitrators. So here, first aspect, are there do arbitrators have the technical abilities to make ruling? And then when it comes to arbitrators using AI themselves, here we've asked some questions, and the findings were generally that I think people really expect some high level of transparency here. So 76% agreed or strongly agreed that there is a need for greater transparency over the use of AI tools by arbitrators. And then 71 agreed that arbitrators should be required to disclose the use of AI tools for any purpose. 74% agreed that they should not use AI tools, so arbitrators should not use AI tools to formulate or draft adjudicatory elements of an award, and 59% agreed that arbitrators should only use AI tools with the prior approval of parties. So very important for those of you who sit as arbitrators to think about these things if you are considering using AI yourself. And also important for counsel if you wish to perhaps give a hint to your arbitrators that if they want to use AI, maybe they should let you know about it beforehand. Now moving on to the impact on AI on the integrity of evidence. We asked respondents about perceived risks of the use of AI tools, and 85% of respondents were concerned about deep fakes. We also asked about respondents how concerned they were about the impacts of AI tools may have on the integrity of evidence adduced in arbitration, and there were 49% rated the level of concern as 7 or above. And then finally, we asked respondents if they had been already in a situation where they were in an arbitration and AI had an impact on the integrity of evidence, and 3% of respondents answered yes to the question, which somehow seems like a low number, but we thought that actually it was quite significant, given that there were more than 200 respondents. At least 6 or 7 people here had already been in a situation where AI had impacted the integrity of evidence, which we thought really showed that, first of all, AI is already being used, and it also shows that there are really risks here in terms of the potential impact on the arbitral process. Now we're moving on to regulation. We've asked respondents if they thought that the use of AI tools in arbitration should be regulated. As you know, I'm sure this is not regulated at all at any level at the moment. So we are in a complete kind of vacuum or blank situation where there's no regulation whatsoever. And 63% said yes, 18% didn't know, and 19% said no. So, vast majority are in favor of regulation, but not everyone. And then we've asked what form should such regulation be in, and 39% of respondents were in favor of soft laws or guidelines, such as the Silicon Valley guidelines, which we've mentioned already, and I'm sure we'll mention again. And 26% were actually in favor of regulating the use of AI tools by way of arbitration rules, which I think is an important number. And it should be taken as a nudge by arbitration institutions here, who will, I'm sure, consider revising their rules and then finally, we've asked respondents to describe AI by choosing words to describe AI in the context of arbitration, of course, and the top 3 words or phrases selected by respondents were inevitable, cost-effective, and opportunity, which again, potentially also springs some ideas for us here on this call, but for the broader community to take those challenges forward. So now, briefly, some lessons, and then I'll hear what my commentators have to say on the presentation, and also, of course, the audience. First takeaway, in my view, is usage. AI, we've seen, is already being used in arbitration, so we're not just speculating here about the future. This is very much a current area. If everybody could keep themselves on mute, that would be appreciated. So first, that's the first takeaway. Second takeaway, there are major benefits, but also real concerns around the use of AI in arbitration. Third takeaway, there needs to be more transparency about the use of AI in arbitration. I'm not sure it will be the solution to all the problems, but more transparency will definitely help. And in my view, this can only be achieved through disclosure of the use of AI, and you've heard some of the answers on our questions on disclosures here. In terms of disclosures, one key challenge will be how we define AI, because if we need to start to disclose everything that we do with some AI embedded in it, then there may be problems. So defining what AI means is going to be key. And then how do we achieve adequate disclosure? We can only achieve disclosures if we have duty to disclose, and duty to disclose will need to come from either regulation, or it will come from arbitrators, who will need to set out duty to disclose AI in their procedural orders. And that will be a key challenge for them, because we've seen in the survey that people are not very confident in arbitrators' technical competency when it comes to AI. overall, I think, another takeaway of the survey is that we need training. Arbitrators need training, counsel need training. We all need to be much more aware of what the tools are, what they do, and what are the risks associated with the use of with such tools. And then last question, which really resonates with the title of my presentation, is even if we achieve more transparency through adequate disclosure of the use of AI, can transparency really make the algorithm fair? In other words, are there any aspects of arbitration that should be safeguarded from the use of AI? And are there any risks associated with AI that cannot be solved through transparency? And I'll give you just a couple for you to think about. First of all, the use of AI in arbitration may give rise to enforcement problems. For example, if AI is not allowed in the administration of justice in the place of enforcement, for example, you can imagine it's allowed at the place of the seats of the arbitration, but not at the place of enforcement. So that's one question. And then finally, in terms of the use of AI by arbitrators, I think we should all ask ourselves, is justice just based on data? In other words, can we ask an algorithm to make a justice decision, to rule on to administer justice? We all know that AI is nothing more than just data. So, as arbitrators, do we just apply the data, or do we actually have add some values, some human aspects, whether it's trust, whether it's fairness, whether it is respect, so query here if transparency could actually, address concerns that people have around AI being used as a system of justice. So I will leave it to that, and yeah, thank you for listening, and I look forward to your input and questions.
Thank you very much, Claire, for not only leading us through the survey, which is interesting and which leads to questions and comments, and I have taken note of a few of them, but and I'm sure other participants will also have reaction, but also for sharing with us your thoughts as to what may come, and also raising, of course, a fundamental issue as to the role of justice as a human exercise versus as a data analytics exercise. So now we turn to you, Pietro Ortolani, for your comments, and then perhaps Claire may want to react, and then we'll move to the second commentator, then Malek, and of course keep time for the open discussion. Pietro.
Thank you. Thank you so much, Jacques. And of course, thanks to all of the organizers for having me, for the invitation. It's an honor to be here. Thanks to Claire, of course, for this tour de force. I think it's really impressive, the amount of data that the survey provides us with, the amount of food for thought. I must say I'm very excited because Jacques, before the beginning of the event, told me that most of you are students, actually mid-students, and I want to learn from you. I think this is one of those topics where young people can really teach us a lot, because you have new ways of thinking, you can be creative, and you are the practitioners of tomorrow. So I would be very curious to know more about what your experience as not the practitioners of today, maybe, but tomorrow, have about this topic. And I encourage you all to think about it. I will use this 10 minutes, no more really, to just ask some open questions, rather than trying to give you the truth, which I don't have, I must disclose up front, just to encourage you to think, and then to hear some comments from all of you. Well, Claire, of course, told us so many interesting stuff. And one thing that I completely agree with her is that we are at a watershed moment for artificial intelligence. That has not only to do with the launch of ChatGPT and its use in legal practice, but also with the fact that finally, after years, the time is ripe to have an honest and meaningful dialogue about the use of artificial intelligence in legal practice and in international arbitration in particular. Why do I say finally? Well, because for a fairly long time, the debate has been stifled by a stereotype, by an unrealistic dichotomy. On the one hand, people thought we have the good old arbitrators. They are reliable. They do things according to a time-tested procedure. They have their own epistemic community, and we can rely on them. On the other hand, we have this brave new world of the robo-arbitrator, of an algorithm substituting the human. Well, this dichotomy has never really been realistic. What is realistic is to think of how different types of artificial intelligence can fit within the practice of arbitration. And from that point of view, I would say, in a way, it's nothing new. Technology has always affected the practice of the law and of arbitration in particular. Think, for example, of a very simple technology, the printed word, that completely changed the way in which lawyers worked. Think of the personal computer. Think of the internet. All of these things have been integrated into the practice of international arbitration, of course. And the same will happen for AI. It is our tool and our task to try to figure out how to integrate it reliably within our practice. Now we have a lot of data. This 221 respondents really gave us a lot of insights into how this could be done. And I think one of the most striking takeaways, don't take it for granted, is that this is not science fiction. It is already here. 28% of these respondents have already used ChatGPT in a professional context, not as a toy out there, but in their arbitration practice. That is stunning, in my opinion. It is a lot, and of course, it will grow in the future. And on top of that, artificial intelligence is routinely used, as we have heard, in document review, in translation, in text formatting, I would say in discovery procedures. There are really already time-tested uses of this type of technology in international arbitration. Other uses are not widespread yet, and yet the respondents have said they seem acceptable. They don't close the door for that type of application. So there's already cases where technology and artificial intelligence in particular is changing the practice of arbitration, and it's even disrupting it to a certain extent. I think that 3% of cases of AI impacting the integrity of evidence is actually very high. I would love to interview those people to learn more about those cases. I think maybe also learning from what didn't work well, what the problems were, and how to avoid them for the future. Now, the respondents also have doubts about other types of uses of artificial intelligence. For example, they doubt whether AI should be used to generate text for use in an arbitral award, in an expert report, or even in a legal submission from a party. And yet, I would say, even there, it's too early to close the door. Let me try to build an argument in this sense. Well, first of all of those respondents prioritize efficiency and cost minimization. Those are important goals. And of course, AI can play a role in that sense. That, of course, does not mean that you can have ChatGPT or any other large language model write an arbitral award. That would be pure malpractice. I mean, we have all laughed about the lawyer that copy-pasted the outcome of ChatGPT into a legal submission in a court procedure in that case, and didn't realize that the precedent that ChatGPT was generating was actually a hallucination. That, I would say, is, first of all, a lack of understanding of how a large language model works, a lack of understanding that it's just a sophisticated statistical model that predicts the likelihood of a word from occurring based on the preceding words in a prompt, for example. So the respondents have pointed out where the problem might be and where AI should not maybe intrude, for example, the adjudicative portions of an award. I agree there. Nevertheless, there are a number of other more clerical drafting tools where we do already acknowledge that arbitrators might get help, for example, from a secretary. Just to make a simple example, drafting a first draft of the procedural history of an arbitration. secretaries sometimes do that, let's face it. And as long as the tribunal then, of course, reviews that draft critically and uses it as a starting point and not just something to be copy-pasted into the document to be signed and what becomes the arbitral award, that is something that can actually enhance the cost effectiveness of arbitration. Now, I think it is our goal, and most of all, your goal as legal practitioners of tomorrow, to think of ways to unlock the benefits of arbitration also for small and medium enterprises, also for relatively small values in disputes. And where a secretary doesn't make sense, might maybe in the future some kind of AI make sense for, again, not delegating decision-making functions, but for example, summarizing some documents for the purpose of then drafting a procedural history and saving some costs. Let me go to the risks. The respondents really mention a lot of interesting stuff there: cybersecurity, confidentiality risks, risks of hallucination, deepfakes. That is all relevant. Absolutely, but it also demonstrates that another important takeaway of the survey, in my opinion, is that AI, as Claire mentioned, is a very broad label. It contains a lot of stuff and a lot of different technologies, from an expert system, which is something that we have had for decades, to a very sophisticated neural network such as Midjourney or DeepL, for example, for translation purposes. Well, those risks would not, in my opinion, apply to the same extent to different types of AI. So we can sometimes talk about AI in general, but in other contexts, it's very good to be granular, to understand the differences between different types of technology, and to think critically to what extent a certain problem occurs with respect to that specific technology. I understand I am making things more difficult for you as the arbitration practitioners of tomorrow, but my hope is that all of you will be able to understand the difference between a neural network and an expert system, for example. That is crucial, in my opinion. Let me give you a practical example, the so-called black box problem, right? An algorithm produces a certain outcome, the users don't understand why, and also the developer himself does not understand why. That is something that can occur with certain types of AI, but not others. And there is a huge movement in favor of explainable AI. If you put it like that, it seems uncontroversial. Who likes opacity, Transparency, explainability, that sounds great. But if you do understand the technology, at least in its basic contours, there is something to acknowledge there. Explainability, typically, up until now, does come at a cost, and the cost is accuracy. Neural networks in particular perform so well. For example, Midjourney is so impressive in generating images exactly because it's a black box, because it is a neural network, because it's different from an expert system, for example. If you want to make the AI more explainable, you might have to leave with a lower degree of accuracy, with more hallucination, actually. So transparency sometimes does make the algorithm less fair, counterintuitively, but that is something that is very important to accept for certain types of AI, not for others, as the reality of the technology we are dealing with at the moment. Of course, things might change in the future. So in light of this, and I do encourage you to be very granular about it, ask yourself, do I need explainability? And in some cases in arbitration, you definitely do. You definitely do. And Claire mentioned, I think, the most important case. It is when the AI plays any role in generating a piece of evidence that the tribunal will need to evaluate. Of course, in that case, it's extremely important for the tribunal to have insight and to be able to scrutinize how that evidence was created. And was it reliable? Again, this is not science fiction. Let me give you a case from practice. Now, here in the Netherlands, the setting aside proceedings for the UCOS case have been a huge saga that you certainly all have read about. And one of the arguments of the award debtor of the Russian Federation was that part of the award had, according to the award debtor, had been written by somebody other than the tribunal, namely by an assistant to the tribunal. How did the parties argue this point? How did they try to convince the court that the award had or had not been partially written by somebody other than this three-member, very reputable tribunal? By providing the court with two different stylometric statistical models that would demonstrate either that the award was written by the arbitrators or at least partially not. Well, in that context, of course, it's crucial for any tribunal or court to be able to look into the statistical model and understand it. And contestability, in other words, is a value that we should never give up. In other cases, to be honest, disclosure might be enough. Let's suppose that it's necessary to disclose the use of AI in reviewing a text to be submitted to the tribunal. And by the way, if you define AI broadly, then a spell check through Microsoft Word also counts. So I don't know if disclosure is necessary there, but even if it is, maybe that is sufficient in that different context. So in other words, my invitation for all of you would be granular, be specific, engage with the technology beyond the stereotype, understand in broad sense at least what the technology is and what it does. On the last point of cybersecurity, very important concern, it is linked to the tech savviness of arbitrators. There's many arbitrators that still are lacking in that respect. And because we are in a group with a lot of young lawyers, let me make a plea for diversity. In fact, I think that a big problem of tech savviness has to do with the fact that many big cases are still decided by arbitrators that come from a different generation. I do hope that with your generation, the problem will be solved. And I hope that arbitral institutions can play a role in encouraging the appointment of new arbitrators, tech-savvy arbitrators, arbitrators that know about the technology and about cybersecurity and can really transport this field of practice into the new millennium. Many thanks to all of you.
Thanks very much, Pietro, for sharing your thoughts and comments. Before turning to Claire, who I'm sure will want to react, I just wanted to also express my interest and even my curiosity about these figures that you presented, Claire, this 3% to which you also referred, Pietro, like these 6 or 7 people out of the 220 plus respondents who indeed experienced cases in which AI had compromised evidence. And I was wondering, perhaps a question to you, Claire, or in addition to your own comments, whether you would have hopefully details as to the circumstances in which this happens, so that we could, and coming back to what you said, Pietro, which makes a lot of sense in many respects, which is granularity, to have an understanding as to what went wrong, what were the circumstances, and how we might want to address that by regulation, potentially as well. Presenting earlier by soft regulation, which seems to be the way to go based on the survey. Anyway, I just wanted to react on that 3% figure, which obviously has triggered our interest based on what Pietro you just said. So turning to you, Claire.
Thank you. I'm afraid I don't have good news on that. We don't. I mean, those cases are confidential, and there is a box for people to provide comments as to complete or just to give observations as to the answers, but we don't have more information on this. So I guess we have to just to take the number as such and draw our own conclusions. I wanted to go back to Pietro's invitation to you all to really embrace all those new tools and really understand not only how they work, but in this context, I think it's very important to come back to the basic. And I wanted to share some criterias or kind of almost like to do not to-do list, but yeah, list of checks you may want to think when you think about a tool and you wonder if it's appropriate or reasonable to use it in an arbitration context. When what is the usage? What is the tool going to do for you? What is the stage of the arbitration you in? For example, a same tool could be problematic, in one stage and not in another. So, what stage are you? Has there been an order, for example, to one or two parties to disclose information already, or has there been a procedural order dealing with those issued? So, what is the tool doing? What stage are you in the arbitration? What is the potential impact of the tool? For example, on due process rights, on the evidence, on right of defense, so the ability for a party to defend itself. That's 3. And lastly, is there any transparency around here in terms of how the tool works? The black box issue we discussed, but also is there any transparency in terms of the use itself? Does the other side know about this? Do the arbitrators know about this? Do I need to disclose this? So I just wanted to share those 4 factors to perhaps keep in mind. I wanted to also kind of react to Pietro's analogy with secretaries, which is very interesting. And again, go back to the basic. When we appoint an arbitrator, unlike the national justice systems where we don't appoint judges, they are assigned to our case as parties. Here we appoint them by person, by their name. We appoint them for who they are as human beings, for their characteristics, for their what we think is their decision-making process, their fairness, their trust, the trust we put in them. And so what that means is that, the mandate for students, among you, the mandate is a personal mandate. I think in Latin is a intuitu personae type mandate. And what that means with this type of contract is that you cannot delegate them. Of course, secretaries is one exception to that. But I wanted to, flag here that, of course, there are good practices in terms of the use of arbitral secretaries, which are, for example, that usually is best practice to disclose the use of a tribunal secretary to parties. So here we can transfer, that best practice maybe to an algorithm. If a tribunal needs to disclose the use of a tribunal secretary, maybe they should also disclose the use of an algorithm, because there's some kind of delegation here. Another problem or issue here is that tribunal secretaries, when they are disclosed and when they are used in accordance with good practice, they need to be independent. They need to do a conflict check like arbitrators need to do as well. What do we do with algorithm? Can we have an algorithm and do a conflict check for an algorithm? So I just wanted to put that out there. And then finally, I think that experts, we often forget that their mandate is also a personal mandate that they have. They are using arbitration to provide their opinion, their personal, professional opinion on certain issues, whether those are technical issues, quantum issues. And here, I think there's another analogy. If an expert uses an AI tool to, for example, come up with a quantum number for quantification of damages, those tools are maybe very, very powerful and efficient, but this evidence that will make its way into an expert report will need to be challenged. And what happens if the expert is in the box and counsel on the other side asks questions about, how do you explain that your opinion is that there's, those damages should be $1.5 billion, and if the experts cannot explain how they came up with this number, that this could really give rise to an issue of due process here. And potentially this expert's evidence could be completely valueless to a tribunal if the expert cannot explain it. So I just wanted to react on those 3 points.
Thank you very much, Claire. Before we shall move to you, Ben, just wanted to draw your attention to the question which has been put on the chat that you may not have had a chance to read, from Hania Al-Naber. Thanks for the question, which, under your control, of course, is in essence whether clients can object to the use of arbitration, to the use of AI in arbitration. I was wondering whether Claire, Pietro, and perhaps the audience, and also to you, Ben, when you get to give you the floor in 2 seconds, but I just wanted to draw your attention to that question. Claire, any reaction on that?
Yes, we've had a lot of thinking. We've introduced some questions to in-house lawyers, as you may have seen the report. In terms of disclosure, I think it is for us, at least in my firm, completely logical and of course ethical to ask your own clients if they would like to have those AI tools being used. I mean, this has an indirect impact on fees, of course, and efficiency. So I think there should be the decision makers there. There's another very, I think, interesting point about ultimately arbitration users deciding on AI, which goes to the very foundation of international arbitration, which is parties' autonomy. And that is the possibility for parties to say in the arbitration clause if they want to have AI being used. And we've been discussing this with our clients. I'm also chairing a task force with the Chartered Institute of Arbitrators to develop guidelines on the use of AI in arbitration. And we have in-house lawyers on the task force, and one of them said that they are his company, his huge actually technology company, is thinking of including a reference in some of the arbitration clauses. So just a sentence saying AI less or free arbitration. So AI should not be used in those proceedings whatsoever, which is very interesting. And I think we're going to start seeing that either very simple reference in arbitration clauses or rules, or very sophisticated ones. You can imagine that, for example, for low value contracts, parties decide to use AI fully for certain types of disputes. So yes, the arbitration user is ultimately the decision making, making kind of the ultimate decision maker for those issues. I agree, Jacques.
Thanks.
And of course, Rania, whose question it was. Sorry, Rania.
Thanks very much. Just sharing, and perhaps some of you have seen that, but in the California Bar has just issued guidelines, ethic guidelines on generative AI, which might provide some guidance on its relevance with respect to the discussion that we're having now. But it's now turned to Ben Malek, who is our second distinguished commentator for the session. Ben?
Yes, thank you. First of all, Claire, thank you so much. Presentation was amazing. Jacques, thank you so much for having me. And Pietro, it's an honor to be here with you. So I am currently the chair of the Silicon Valley Arbitration Mediation Center AI Task Force. We came up with the idea, or not with the idea, after we saw the SVAMC case create waves in the legal world of, as Pietro mentioned, of a lawyer that just took ChatGPT's output for good and handed that into the courts. We realized that it is really only a question of time until something needs to happen. Whether that is guidelines, whether there are rules, whether parties will need to opt in or opt out. but something will need to happen in arbitration. The courts have now in the US specifically, they came up with this idea that AI, or if parties use AI, it needs to be disclosed. And it's a blanket disclosure, so it's not really helpful. So what we were trying to do is create some sort of guidelines to enhance practitioners and arbitrators with some tools on how to properly use AI. Why I say that is because as much as we all say, or as Claire just mentioned, AI less arbitration, I think what that is referring to would be generative AI less arbitration, just because AI in general is inevitable. It's here. A Google search, even just an internal search within a law firm looking for a document could already be considered AI. So I guess the truth is, what do we consider AI, and where do the issues start, or where can they start? And this is what we try to address with our guidelines. So it was really interesting to see during the process of coming up with these guidelines. We of course heard of Claire's project with the questionnaire, and at first we got a little nervous, because we said, what if this will turn everything upside down, and everything we've worked for, all the guidelines we tried to come out with, will be oblivious, like it wouldn't have any impact. Fortunately, the questions were extremely helpful, and in general, just the questionnaire was so in line with what we had thought, which was amazing. It was actually helping us to see that we're moving in the right direction, and we came up with similar issues to address. One of the biggest one being disclosure, and then of course we tried not to address cybersecurity because it has been addressed so often in different guidelines, and every institution has their own. But of course, disclosure is a big one, and then safeguarding confidentiality, as well as drawing awareness to what AI is and what it can do. So the idea is not only to say, hey, we're going to use these guidelines, what do we do in case ABC, but rather also to draw attention to the fact that AI is not free of biases. AI does hallucinate, and many other issues that come along with AI that are absolutely inevitable, but that we believe is crucial for arbitrators and practitioners to at least know or have read somewhere. And one example of that is selection of arbitrators. If we are to go with AI in the selection of arbitrators, which is great, it's a good idea, unfortunately, we will see that we will have a predominantly white male outcome, just because most awards in the past have been written by white male. It's not a bad thing, but one has to be very conscious of it and actively try to compensate biases with real person intelligence. So not artificial, but real person intelligence. And that is just one very basic example of where biases come in. Regarding confidentiality, I mean, that was one of the biggest issues, if I recall, from your study, Claire. And we also drew attention to that and said, in essence, confidentiality is the reason, or one of the main reasons, people go to arbitration. So that really shouldn't be on the table to potentially lose. So we needed to see, how can we safeguard confidentiality? And quite frankly, it again depends on counsel on how they, counsel and arbitrator, sorry, on how they manage cases and how they manage data. If people are to use AI, that's perfectly fine. If people want to use ChatGPT, they can do so. But the idea is to be aware of what ChatGPT is, that it is an open AI and not a closed circuit AI, and that if confidential information is put out there, then it is out there. It's not something that can be retracted. However, there are certain tools, and some big law firms have already implemented some sort of closed circuit AI or closed circuit generative AI, where all the databases of arbitrations are stored internally. And if one would look up a sort of closed circuit ChatGPT, if I may call that, they would find answers, and ChatGPT would be able to actually render information while keeping confidentiality and basing that off of the information that was input by either the practitioner, by the team, by the firm, etc. So it is just important to understand that these are options. I will say, of course, I did see at the end of the chart, Claire, that one of the biggest, or not one of the biggest, but another concern I saw somewhere was cost or expensive was one of the key words. And that is absolutely true. If a firm has, if somebody works for a big law firm and a big law firm has a lot of money and wants to implement in generative AI, then of course, generative AI will be available more easily, more secure, more confidential to practitioners there rather than a solo practitioner. But that does not mean that the solo practitioner is unable to use generative AI. There are tools that can be used. Quite frankly, at this point, we didn't look at it from a recommendation standpoint, rather from an educative standpoint, asking people to inform themselves. And quite frankly, not even asking people to be informed, but rather to be curious. What is AI? Where is it? Why is it developing the way it is? And why should we even learn about it? So I think that was the main focus of where we were going. Our biggest challenge was disclosure. And I think the reason I say challenge is because as we're coming up with guidelines, what do we disclose and how do we disclose? Is a blanket disclosure enough? And we came up as a drafting subcommittee, we came up with the idea that a blanket disclosure is not only not enough, there's no point to do that, because what would happen is every arbitration would have a blanket disclosure saying we used AI. And it doesn't help. It doesn't help the process, it doesn't help the parties. It would potentially help in an enforcement stage if we take the scenario Claire mentioned, that we are in a jurisdiction that either doesn't allow AI or asks for the disclosure of AI. At least one would be covered. But it's not about being covered in arbitration. In arbitration, we go a little deeper and we say, how do we make sure that our case is really safe in the sense that due process were not violated on a public policy standpoint, but also on a procedural standpoint, right? Whether it is an administered arbitration or an ad hoc. So we couldn't, as a subcommittee, I'll say it again, we couldn't decide on one method of how to properly disclose. We couldn't, we were 8 people from big law firms to independent arbitrators to retired partners in big law. And we just couldn't come up with one disclosure method that would be perfect for us to say, hey, this is it. Colleagues, this is the disclosure process we would like it to have. Rather, we came up with the idea and asked practitioners from the sphere, from our society, from our arbitral network, to comment and to let us know what they believe is best. Why? Because in the end, if we come up with guidelines that people are not going to use, then we might as well not come up with them. So we came up with 2 options. And up until today, we're not sure how to go. We have seen some feedback on which jurisdictions believe one procedure is better than the other. But to be precise or concise, these 2 options narrow down to 2 issues. We have an option A that would say it would be up to the parties to disclose whenever they believe disclosure is necessary on AI. And the issue with that, I believe personally, and we discussed in the subcommittee, is that it could create some sort of guerrilla tactic where every document that is submitted can be subject to show us that no AI was used, or can you ask the arbitrators to intervene and show documentation, and all of a sudden an arbitration process becomes more expensive rather than less expensive. Or an option B, which as you can tell from my description of option A was the side I cited on. Option B, which was a 2-prong test, where we would say if AI was used, if AI was used and it had an material impact on the case, and 2, the submission was made using AI and could potentially cause a different outcome, then it needs to be addressed. We took that approach and we implemented those in experts. So we would say that if an expert submission or opinion or other document is materially relied upon, and the AI tool could have a material impact, then we would need disclosure. And we took that on and said the same would go for submissions from parties. And for tribunals, we took a little different approach, because we said in the end, the same way a tribunal would decide what to disclose and when, because we believe that the arbitrator has some power in deciding what is appropriate to disclose and not. Sure, challenges can come afterwards, but initially we always start with the premise that the tribunal would know what to disclose and when. We gave the tribunal a little more leeway, saying that if AI was used in the drafting of a decision-making process, then we suggest the tribunal disclose it. Why do I say that? We debated a lot what language to adapt, and we started off with tribunal secretary language. However, it is a little different. There's two things that are different. First of all, tribunal secretaries are human beings that do run conflict checks. AI doesn't run conflict checks, and depending on how we use AI, it might not even be closed circuit, so we can't even run a conflict check because it's a global database. And second of all, the thought was this: we believe, first of all, or in a subcategory, that tribunals do have some sort of autonomy to decide whether they can use AI to merely summarize procedural history, or whether they would ask AI to summarize submissions on which they base their decision on. And those would obviously very differently impact the outcome of an arbitration. So we looked at it, and we also said another thing. We said, if we start restricting AI at this very beginning stage, because right now we're only starting to play with AI, we haven't really seen what AI can do. This is the beginning. It might restrict too much wiggle room in trying to see how much AI can actually benefit the international arbitration community. And what I mean by that is very simply, we've used tribunal secretaries for at least 100 years. I take 100 years from the ICC. The ICC celebrated 100 years. We are confident that tribunal secretaries, one way or another, have been used since the inception of arbitration, or the inception of arbitration administered by the ICC. In what way they were used, we don't know, because they were not disclosed. It wasn't, we only talked about disclosure a couple of years ago, 5 years ago, maybe 6 years ago. We started talking about what do we need to disclose. Before that, paralegals were used, senior associates, maybe junior associates were used at a bigger law firm to help the arbitrator draft and do research. All of this was not disclosed because we just didn't have the theme of disclosure. Now we're talking about disclosure, and of course we want as much to be disclosed as possible. But if we don't give arbitrators the wiggle room to see how much they can actually use and how little or how much they want to use AI, I don't think we will get to a point where AI is really truly helpful to international arbitration. Yeah, that's where we are. I gave a little overview, but in total, I do have to say that Claire's questionnaire was impressively helpful. We felt when we read through it, because it came out before we actually published our guidelines, we felt like either somebody was mind reading, or we were really on the same path. And it was truly pleasant to see that we are on the same boat, and that people do want guidelines. As we saw in Claire's slides, around 60% of practitioners do want guidelines. I will also say, just to add to the statistics, when we from the SVAMC talk to different institutions and talk to different group of practitioners about these guidelines, we have only received one pushback, on guidelines, and we were asked for a white paper instead of guidelines, because guidelines would be oblivious, given that they would intersect with ethical rules. And I completely understood, because the people we were talking to were at the New York City Bar Association, and New York, or specifically the United States, has a very high standard of ethical rules. The issue we had with that, and the reason we moved forward with the guidelines, is because as much as we appreciate that feedback, it shows that the culture in that area, New York City particularly, but the US, has a very advanced ethical standard, whereas the rest of the world might not be there. Eastern Europe, for example, has some sort of ethical standard which may or may not apply depending on where we are. And as we know, we like to have some sort of baseline in arbitration. And I think these guidelines would really help with some sort of baseline. And I will quickly end in saying, Jacques, thank you very much. Our survey is currently still pending. You have time, and we take comments from everyone and anyone in the arbitration community. You can go on the link which was shared in the chat earlier and submit your comments on the current draft until December 15. And if you do have any questions, please feel free to reach out. And thank you again for having me.
Thank you very much, Ben, also for explaining and presenting what you've done at the Silicon Valley Arbitration Mediation Center. We very much look forward to seeing the final product. Or I'm not sure whether we can assume that it will be final, because I guess it will be evolving over time, obviously, and also for pointing out to the same need for granularity and just like defining exactly, of course, from a tech perspective, what we're talking about, what's supposed to face, and how we're supposed to address that by potential regulations. Claire, would you like to react to what Ben just said, and perhaps also Pietro afterwards? Claire.
Thank you. Lots of really interesting disclosures, maybe I should say, about the task force workings and thinking. So thank you for that. It's very interesting to also know, and I'm glad that you found the questionnaires helpful. I have a few small points, and forgive me, I want to be brief, but they're quite piecemeal. So I'll try to be fast. On arbitrators' use of AI, we need to mention the draft EU AI Act, because if we don't do that, we wouldn't be complete. The current draft of this piece of legislation actually refers to use of AI systems intended for judges, administrative bodies, and arbitrators. And the current thinking of the EU Commission is to classify those AI systems as high risks. So there is a chance that actually the use of AI by arbitrators will be regulated not only within the arbitration community, but also at state level. So I think we should all watch this space carefully, because even if it's a European, there would be a European regulation. This will have huge impact in terms of its application. For example, the ICC being headquartered in Paris potentially could apply to all ICC arbitration. So I think it's very important to keep that in mind, that in addition to any regulations within the arbitration world, there will be other regulations. On cost, I thought your point was very important, and and we need to think about the benefit of AI. And then whether when you want to use it, whether the way we use it could actually collide with the benefits, and if we create more obligations in terms of disclosure, or in terms of simply the cost of those tools, and we make arbitration less effective because of that, what's the point in trying to be efficient in using AI? And that reminded me of the common approach that people take with hallucinations, is that people say, that's fine, you need to supervise the AI properly. Okay, there may be a situation when you supervise the AI, but if you need to supervise everything that AI does, are you not losing the benefits of using AI? So have a think about that. also a related point on cost is the impact on the environment. So, you know, arbitrations will need to become greener and greener, you know, as we all, you know, aiming at reaching net zero targets. So, you know, that's one of the things that we haven't explored in the survey, but the impact of AI on the environment is massive. So again, you know, a potential tension, I think, for us to think about. Another tension actually is disclosure and privilege and potential tension between disclosing how AI has been used by one party in particular, and the work product doctrine in the US or litigation privilege in England. We think that there will be also arguments around that. So if you don't want, you know, the other side to look into what you've been doing and using in terms of using AI, maybe the best solution is not to use it at all, right? So again, you know, some tensions to consider. And I will maybe finish on that point, which is the bias point. I wanted to maybe be a little bit controversial here. I think, you know, it's true that the data is biased, for example, in terms of arbitrator selection, but I wanted to also flag the fact that actually sometimes the data is less biased than a human. So, for example, the use of predictive coding, which is an algorithm to identify relevant documents as opposed to search terms or date ranges. When we use predictive coding, which is allowed in the English courts and also in the US courts, this always has to be disclosed to the courts and the other side, of course. In arbitration, people also use predictive coding, but there's no obligation to disclose that. But my point is not about disclosure, actually. It's about the fact that, you know, if we compare using the traditional method of identifying relevant document to comply with an order of a tribunal, the traditional method effectively consists of using a group of paralegals, typically, or trainees, you know, or junior lawyers, and all those people, sometimes they can go up to like 20, 30 people. They will often not be admitted to practice law in the jurisdiction. Sometimes they're not even, you know, close to the case, so they don't really perfectly understand the issues. And they will come up, you know, they will actually tag the documents from their own perception. So they will kind of apply, you know, human judgment to this. And so what that means is that effectively there are some errors, and it's somehow biased, you know, the way that those documents are tagged and ultimately disclosed to the other side. And, you know, that evidence forms the body upon which a body of evidence upon which the tribunal rules and makes a decision on the merits. If we compare that traditional method with predictive coding, where the algorithm is trained by one single lawyer, usually a senior lawyer who is close to the issue and is admitted to practice in the relevant jurisdiction, in that case, the algorithm is much more accurate and much less biased than the traditional method of identifying relevant documents to comply with an order. So, and this has been proven, this is based on lots of research, you know, that has shown that predictive coding, so the use of AI in that context, is much more accurate, much more secure than human review. So maybe I can finish with that kind of same point I made earlier. Just think about the tool itself, think about the context, what it's doing, the impact it will have on the case, and also how transparent it is. Because I think we will really have to ask ourselves those questions every time we think about AI in the future. And of course, we'll have to think about that every time new tools, new functions, new use cases also become available on the market. Thank you.
Thank you very much, Claire. In the meantime, we received perhaps provocative question on the chat that you may have seen, and perhaps I can ask it as a last question to our speaker and commentators, and perhaps starting by you, Pietro, if you wanted to react. also to what was presented earlier, but also close to that question whether, if I quote that question on the chat, whether the pre-existing procedural safeguards in arbitration, including due process, are enough basically to deal with the risk of generative AI. Obviously, we will not find solutions, I guess, also because we just have 4 minutes left based on the timeline that we had planned. But of course, that shows how lively the discussion is and how much there's still to discuss. But perhaps to you, Pietro, if you wanted to briefly react on that.
Yeah, thank you so much, Jacques. And of course, thanks to Claire and Ben for the really great conversation. Had a lot of fun. Starting from this question, provocative, but also, I would say, very, very to the point. In fact, what we are discussing up until now is partially just that. If you look at the attempt that Ben and his colleagues have done to create these rules, it is practically to keep the framework of arbitration that we have, but to fill it with new guidelines, with new concepts that allow us to work the old framework in the new reality of AI-enhanced arbitration, to call it that way. So the cornerstones of arbitration, think of due process, think of party autonomy, think of equality of arms, will stay there, and they will get a lot of the work done. But to allow them to get the work done, you need to fill in those general notions with AI-specific interpretations, understandings, and maybe soft law to complement to it. This is nothing new. We have done it again and again, and that's the beauty of arbitration. I mean, the community is agile enough to be able to integrate new aspects of life, really, into the way we do arbitration, while keeping the framework that we have had for centuries, in fact, to govern arbitration. Very quickly, on the other point, and that's the only other point I will address, are the comparison with secretaries. Of course, the comparison works until it doesn't. It's not the same thing, right? If anything, because we've had secretaries for centuries, and we know relatively little about the use of generative AI. And yet, nevertheless, if I had to play devil's advocate, I would say sometimes maybe the use of a human secretary has additional dangers that the use of Gen AI doesn't have. To make a practical example, you have a young secretary, a very talented person. As a lazy old arbitrator, you might be tempted to say, well, what do you think? Actually, do you think this is a fundamental breach? Then, of course, I'll make up my own mind, but you wrote a PhD about it. What do you think? Well, that is unacceptable, right? That is really pulling the secretary into the deliberations. And it would be up to the secretary at that point to point out that it's not for him or her to share their opinion, and they should leave the room, most likely, which is very hard to say to a reputable arbitrator. Now, that is a danger realistically you wouldn't have with generative AI. But of course, you have other important dangers to consider. Right.
Thanks very much. It would be a breach of contract committed by me if I were to extend much longer the session, but I see that Ben has activated his mic. So please, Ben, give you the floor perhaps for last reaction, and then to Claire as our speaker, and then we should wrap up, I think. Ben.
Yes, thank you, Jacques. Yeah, to Pietro's point, I truly believe that it is extremely important that everyone works together. I think AI can only, as anything in arbitration, can only prosper if everyone's pulling in the same direction. The one thing I wanted to add was just regarding Ranya's question from earlier, Rania Alnaber. She was asking, if a client says they don't want to use AI, whether you should still use it or not. And because there are a lot of students here, I did just want to say that from a practitioner's point of view and arbitrator point of view, obviously, you always have to appease the client because the client's the one to pay the bills. I mean, that's what it comes down to. Not working at a firm, I can say it now, right? You got to make sure the client's happy, got to make sure the partner's happy. But ultimately, we are hired for our expertise. And we need to make sure that the client knows that we know better. Of course, the client can still say, don't use AI. But if we make a case and show that, there's no way to avoid, I mean, in this case, it's very general. AI is no way to avoid completely AI because our research tool is on AI. We could try, we could avoid some sort of generative AI, et cetera, et cetera. I think those are very important things to just keep in mind, that in the end, we represent the clients, and that's why we have guidelines for practitioners, not for clients in general. And that goes, again, I'll just close with something that is tangentially relevant here. But I always say this, I say that it is up to the practitioners to support more female arbitrators being appointed by adding up female arbitrators on the list and selling those to the clients, even those that don't want female arbitrators to be appointed, to say, hey, you hired me, trust me, this is my expertise, these are good candidates. Now, whether that will change from today to tomorrow, I don't know, but I think that is something to think about, especially as aspiring practitioners, on how one should sell the firms and the expertise to a client. And thank you again, Jacques, for inviting me, Claire and Pietro. Thank you.
Thanks very much, Claire. Any final reaction on your side?
I just want to go back to the question, Ramin. I think you really, this question really sums it up. Some people have said, AI is just another tech tool. Why do we need guidelines or regulation on tech tools? We've been using tech tools for ages. I would just say that we should look more at the use of AI that has been going on for a number of years in the courts, like predictive coding, and take lessons from that. And I would say that transparency is one of the key principles that is referred to for any kind of use of AI, whether it's AI in defense, in medicine. Transparency is really, really important in terms of the use of AI in any sector. So I think we will never achieve transparency if we don't have some regulation around disclosure. So I'm giving too much away about the way I'm going, but yeah, thanks again, and thank you for staying with us so long, and thanks for the organizers and for having me. It's been a real pleasure. Thank you.
Many thanks. Let me briefly wrap up. Many thanks, a big round of applause, and I'm mute in clapping my hands virtually to our speaker, Claire Morel de Westgaver, and to our commentators, Pietro, Ortolani, and then Malek. Truly great session, a lot of food for thoughts, and also important guiding principles, agility, granularity, tech savviness, of course, quite important, and transparency, among many others. Let me also thank the team at the Digital Law Center who has helped and helps significantly for the organization of this session, specifically Amir Joseph. Many thanks to you. Let me also briefly mention the next session of our AI TPT series will be on the 20th of February. Will be about automated decision-making in commercial transactions, legal framework for algorithmic contracting, different topic, but which may have some connections. And this being said, let me now wish all of you an excellent holiday season and best wishes for the new year. Thanks very much, and see you next year for the next edition. Thanks very much. And to the speaker and commentators, perhaps we can go to a breakout for a brief session. Thanks very much.
Thank you.
Bye-bye.
Bye.